Good morning, everyone. We're just going to wait till people get signed in, so just give us a couple minutes. All right. Good morning. We're going to get started. Thank you all so much for joining us today. My name is Nicole Safar, and I'm the Executive Director at Law Forward. Today, we're joined by national and Wisconsin legal experts, including Dan Lenz from Law Forward, Ruth Greenwood, Director at the Election Law Clinic at Harvard Law School, Mark Gaber, Senior Director Redistricting at the Campaign Legal Center, Law Forward co-founder and chair of Stafford Rosenbaum's political and election law team, Doug Poland, and Law Forward board president and partner at Stafford Rosenbaum, Jeff Mendel. This is an on-the-record briefing, and we'll be taking questions via the chat function after prepared remarks from each of our speakers. For your questions, please enter your name, outlet, and question in the Q&A box. We will do our best to answer as many as possible in the time that we have this morning. If we don't get to your question, we'll definitely follow up via email with an answer later. You will also hear from one of our plaintiffs in this case, and I'm going to turn it over to Jeff to kick us off.
Good morning, everyone. Today is an exciting day for Wisconsin. On behalf of 19 individual voter plaintiffs and every resident of this state, we filed a new case to end the extreme partisan gerrymander that has distorted our state for more than a decade. It's my privilege to give a brief overview of the claims contained in today's filings. The extreme partisan gerrymander that has changed everything in Wisconsin for more than 10 years now is an affront against democracy and a violation of our state constitution. Every day that it continues is a violation of the most fundamental rights of every Wisconsinite. It must be ended as soon as possible. And that is why this morning, we filed a petition for original action directly in the Wisconsin Supreme Court with the goal of achieving fair, equitable maps in time for them to be used in the 2024 legislative elections. Our clients are individual voters from across the state. They are diverse not only in geography, but in their own personal demographics and stories. What they all share is a deep-seated objection to the extreme partisan gerrymander and an understanding of how it has damaged Wisconsin and changed their own lives. Our petition names as respondents not only the Wisconsin Elections Commission and its officials, who are responsible for overseeing elections in this state and are therefore the people who implement the current gerrymandered maps, but also half of the state Senate. The named senators, all of those, regardless of political party, whose districts would not otherwise have an election until 2026, are named because we are asking the court to declare the current districts so constitutionally defective that no one can continue representing those districts once their maps are in place. Of course, in compliance with Wisconsin law, we are also serving copies of today's filings on the Attorney General and the legislative leadership. Our petition advances 3 substantive claims. First, we ask the court to hold that partisan gerrymandering violates the rights the Wisconsin Constitution guarantees to every resident of this state. In 2019, when the United States Supreme Court dismissed the Rucho case, challenging the partisan gerrymander in North Carolina, it expressly invited people unhappy with partisan gerrymandering that takes the issue up with their state court under their state constitutions. Today's lawsuit accepts that invitation. It asks the Wisconsin Supreme Court to consider questions that have never been asked before. Does partisan gerrymandering violate the Wisconsin state constitutional promise of equal protection? Does partisan gerrymandering violate the Wisconsin state constitutional promises of free speech and free assembly? And does partisan gerrymandering violate the state constitutional right to have a free government? To reach these questions, the court will first need to determine that it has the power to adjudicate a challenge to the partisan gerrymander. We strongly believe it can and it should take this case on. Failure to do so would mean that our constitutional provisions are mere hollow promises, rather than declarations of individual rights as Article 1 of our Constitution presents them. Second claim, we ask the court to hold that the current gerrymandered maps are facially unconstitutional because they contain districts that are not geographically contiguous. In both chambers of our legislature, a substantial majority of the current districts contain non-contiguous islands of territory, so that some constituents within a district must travel through another district, or even through two other districts to reach their fellow constituents in their own district. Contiguity is a bedrock requirement for both Assembly and Senate districts. It is expressly mandated in sections 4 and 5 of Article 4 of our state constitution. Since the current maps fail this basic test, they must be declared unconstitutional and replaced. Third, we ask the court to hold that the current gerrymandered maps violate the separation of powers enshrined in our Wisconsin Constitution. Our current legislative maps were imposed by the Wisconsin Supreme Court when the legislature and the governor could not find agreement on new maps after the 2020 census. There were maps passed by the legislature and vetoed by the governor, and those are the maps that are currently in place that were ultimately imposed by the court. The problem is that our state constitution allows only one avenue for overriding a gubernatorial veto. That is a supermajority vote in each chamber of the legislature. Nothing in our Constitution allows our state Supreme Court to enact into law a bill that failed to go through the full lawmaking process set out in the Constitution. For this reason as well, the current maps must be declared unconstitutional and replaced. Having given this brief overview, I'm going to turn it over to members of our all-star legal team, beginning with Ruth Greenwood, Director of the Election Law Clinic at Harvard Law School.
Thank you, Jeff. Hello, yes, I'm Ruth Greenwood. I'm the Director of the Election Law Clinic here at Harvard Law School. The mission of our clinic is to bring novel academic ideas to the practice of election law while training law students to be the next generation of election lawyers. We aim to build power for voters, not politicians, and recognize that the struggle for voting rights is a struggle for racial justice. 9 years ago, I met Bill Whitford. He told me that he wanted to challenge the Wisconsin Assembly map as a partisan gerrymander. He told me he lived in Madison and he understood he was probably always going to be in a Democratic district, but he had friends down in Richland County and he had some up in Columbia County, and they'd been drawn into districts that could have been Democratic or at least competitive, but were now solidly Republican. It didn't matter how much door knocking he joined them to do. It didn't matter how many fundraisers he held. The outcomes were preordained. He was as undeterred as I was by the long odds of overturning a state legislative map in court. And so we worked together on the lawsuit that became the US Supreme Court case of Gill v. Whitford. For the first time in that suit, for the first time ever in that suit, a federal court struck down the assembly plan that was Act 43 as a partisan gerrymander. Sadly, as you probably all know, and as Jeff just referenced, the US Supreme Court eventually decided that partisan gerrymandering claims are not justiciable under the federal constitution in the Rucho case. So Bill and all of our other plaintiffs got no relief. But the Supreme Court made clear that state courts can take a different approach. And some states' courts have done that, places like Alaska, Pennsylvania, New Mexico. So when Wisconsin adopted almost exactly the same gerrymandered map in 2022, like most of the people in Wisconsin, I was mad. And then when Law Forward said they were going to do something about it, I enthusiastically signed up. Just like all of the awesome plaintiffs that I worked with for many years in the Whitford case, I have now met wonderful new people who are part of our petitioners team. And I just wanted to talk to you about a couple of the people that I've spoken with as we developed this case. So the named petitioner, Rebecca Clark, lives in Sheboygan. That is a city, as somebody who's not from Wisconsin, I shouldn't know as much as I do about Sheboygan, but I do. It was the heart of an assembly district from 1970 to 2011. Since the gerrymander, it has been split into 2 districts that will solidly always be represented by Republicans. We know that because people like Rebecca ran for office in 2016 and 2018, and so Democrats' voices are not heard. Rebecca is a park naturalist and vigorously opposed the decision by the state to stop funding state parks. She learned that something like 120,000 comments were received by the legislature on the question of state park funding, every single one opposed to the state withdrawing funding. And yet, because of the gerrymander, they didn't have to listen to those voices and they withdrew state funding. Now, even though Wisconsin has a Democratic governor, so some things can be vetoed, the effect of the partisan gerrymander can still be felt. Another one of our petitioners, who you should all talk with, she's amazing, is Dee Sweet. She's from way up in Bayfield, and she's a citizen of the Anishinaabe Nation from White Earth. Among other things, she is the native vote manager for Wisconsin conservation voters. And she told me about how the gerrymander had affected her life and work. In terms of policy, there aren't enough members of the legislature that support her vision for conservation values in Wisconsin. That is because the districts have been drawn to stop those views being heard. But also, Dee does voter registration and get out the vote work in tribal areas, places like Sawyer, Vilas, and Outagamie counties. She explained to me that she's tried to help people who, because of the gerrymander, get confused, end up at the wrong polling place. That's because the wards get gerrymandered to fit the gerrymandered districts. She spoke about one young man who got himself to a polling place despite not having a car. She then had to arrange to get him to another polling place, which was over half an hour away, and then find another ride for him. And even though problems like this occur everywhere, the impact can be really stark in vast tribal areas. And Dee summed it up best, I think, when she said, it's not just that the gerrymander affects people's ability to participate in democracy, though it does. She said that it gives Native voters a feeling that this democracy is not for them. I am so proud to be working with many of the brilliant lawyers that I worked with in the Whitford case. So Doug Poland, Annabelle Harless, Nick Stephanopoulos. And I'm also working with brilliant new lawyers that have had success bringing partisan gerrymandering claims in other states like Stanton Jones and Elizabeth Theodore, as well as all of the amazing lawyers at Law Forward. And you'll hear from others today that we are all really excited and eager to represent Wisconsin voters who have been shut out of the political process for 12 years. We are trying to bring democracy back to this wonderful state. I'll now pass over to another one of our incredible lawyers and native Wisconsinite, Mark Gaber of the Campaign Legal Center.
Thank you, Ruth, and good afternoon, everyone. As Ruth said, my name is Mark Gaber. I'm the Senior Director of Redistricting at Campaign Legal Center and a proud native resident of Rhinelander, Wisconsin. CLC is a national nonpartisan nonprofit organization that is dedicated to advancing democracy through law. We do that in a number of ways: voting rights, campaign finance reform, but as I am concerned with respect to redistricting and stopping both partisan gerrymandering and racial vote dilution across the country. And on this, with respect to partisan voting, partisan gerrymandering, we aim to stop that, whether it's done by Republicans, as is the case in Wisconsin, or whether it is done by Democrats, as is the case in some other states. And so Wisconsin is the most gerrymandered state in the country. In 2011, the legislature, Republicans gained control in the Tea Party wave of 2010. And in 2011, the legislature engaged in the most extreme version of gerrymandering that we possibly have ever seen, and drew maps that would result in the voters of Wisconsin never being able to elect a Democratic majority, not just the Democratic voters of Wisconsin, but independents and Republicans who might sometimes wish to switch their views in a certain election or to send a message to incumbents. The 2011 Republican legislature ensured that Wisconsin voters would never be able to change their minds, that they got one shot in 2010 to elect Republicans, and it turns out that was going to be the only election that ever happened for the legislature in perpetuity. And so we're involved in this case to put an end to that and to bring democracy back to the state. I want to talk a little bit just about some of the facts about the map and why it is so gerrymandered. So there are 99 assembly districts in Wisconsin. There's 33 state Senate districts. And in the 2018 election, as an example, Democratic candidates across the state voters across the state selected Democratic candidates by a 53 to 45% margin over Republicans. Now, as folks who are from Wisconsin, as I am, or cover Wisconsin, as all of you all do, know, an 8-point margin in Wisconsin is a landslide. That is not the type of margin you typically see in Wisconsin elections, which are almost always decided by a few thousand votes, a few percentage points in either side. But 8 points is a landslide. The people of Wisconsin in 2018 wanted a Democratic majority legislature. That's what they voted for. But what did they get? They got 63 Republican seats in the legislature and 36 Democratic seats in the state assembly. That's an 8-point margin in favor of the party that got the fewest number of seats. That is not what a democracy looks like. Now, the current maps that are in effect today are even worse. Take a look at the 2022 election. Governor Evers was the top vote getter of any statewide candidate in the 2022 election, and that was with 51.2%. So as I said, very close statewide elections, an evenly split electorate in Wisconsin. He carried 38 of the 99 assembly seats. Now, Senator Ron Johnson, the Republican incumbent, also won. He won by a smaller margin than Governor Evers did. He defeated Mandela Barnes by a 50.5% to 49.5% margin. And when he won by 1 percentage point, he carried 23 of the 33 state Senate seats in Wisconsin. That's 70% of the state Senate seats were carried by Ron Johnson in a 1-point spread. Now, state courts across the country have invalidated partisan gerrymandered maps that are far less extreme than this. And what we're asking the court to do here is to follow the lead of those state courts who are enforcing their constitution's principles of equal protection, free speech, freedom of association, and the right to have a free government that is elected with the consent of the governed and not with the consent of a legislature that happened to win 13 years ago. As Jeff mentioned, there are also a number of other constitutional violations here, including the most basic one. 55 of the assembly districts don't even consist of contiguous territory. There's little bits and pieces of the districts in surrounding districts. And that just is the most basic requirement of the state constitution that along the way has just gotten forgotten. But the Constitution's text has to be followed. And so with that, I'm going to close by just saying that we are hopeful that the court will see fit to correct this egregious constitutional violation. The voters of Wisconsin should not suffer through another election in this anti-democratic, small d democratic system. So I'll turn it over to my colleague, Doug Poland from Stafford Rosenbaum.
Thanks, Mark. Good morning, everyone. Along with Jeff Mandel, I co-chair the election and political law team at Stafford Rosenbaum, a full-service law firm with offices in Madison and Milwaukee. Jeff and I also co-founded Law Forward. Historically, Wisconsin has had government that has been mostly divided in the control of the legislature and the office of governor between the two major political parties, Republicans and Democrats. On occasion, one political party has had control of the legislature and the office of governor, such as when Democrats won statewide elections in 2008 and controlled both the legislature and the governor's office for 2 years, from 2009 to 2010. But as so often happens in Wisconsin elections, the pendulum swung the other way. And in 2010, the Republican Party won midterm elections and gained control of the Wisconsin Assembly, Senate, and the office of the governor. But when they swept into office in 2011, the Republicans in the legislature did something that had never before been done in Wisconsin's history. First, knowing that 2010 was a census year and that new Assembly, Senate, and congressional districts would be created in 2011, Wisconsin Republicans deliberately set out to draw new legislative and congressional district maps that not only would give them a majority of those districts in the next election cycle in 2012, but that would capture control of the legislature and congressional districts for the entire decade. And make no mistake, although we didn't find out about it until years later through discovery and litigation, the effort in Wisconsin was part of a broader national effort to capture state legislatures in key swing states like Wisconsin for the purpose of cementing control over those states' lawmaking processes for years to come. And that is exactly what happened in Wisconsin. The maps that the legislature adopted in 2011 implemented a massive change in districts from the districts that had been put in place by a federal court in 2002. And even though the districts implemented by the federal court in 2002 had a built-in advantage for Republican candidates, they were still not so extreme that they prevented Democrats from winning the Assembly and Senate in the 2008 election. But all of that changed with the districts the legislature put in place through Act 43 in 2011. And although we challenged those districts in federal court in 2012 and succeeded on a Voting Rights Act claim that changed 2 of those districts, the remainder of the districts remain intact for the entire decade. We also challenged the districts in federal court in 2016 in the Whitford versus Gill case that Ruth Greenwood mentioned earlier, and we won at the district court, only to have that win undone by the United States Supreme Court, which held that federal courts cannot hear partisan gerrymandering claims. But at the same time, the US Supreme Court said that state courts could provide the type of relief from partisan gerrymandering that federal courts were powerless to provide. Well, that meant that those extremely gerrymandered districts have held sway for 12 years now, giving one political party a monopoly on what legislation comes to the floor of the Assembly and the Senate for a vote. And throughout the decade, the power of the gerrymander was used systematically to enact legislation that restricted voting rights and made it harder for all Wisconsinites to vote, while at the same time preventing other legislation that the majority of Wisconsinites want, such as expanding healthcare coverage, enshrining reproductive rights, implementing nonpartisan redistricting, protecting our drinking water, funding our public schools, and many other similar types of policies. They've prevented those from becoming law. Well, we are now following the course of action that the US Supreme Court expressly suggested in its 2019 decision in Rucho versus Common Cause. And we are coming to the Wisconsin Supreme Court to finally put an end to this insidious partisan gerrymander that has effectively shut the majority of Wisconsinites out of any meaningful representation in the Wisconsin legislature for more than a decade. I'll turn it back over now to Nicole.
Thank you so much to all of our amazing and brilliant lawyers for sharing a little bit more about the case. I am going to share a video right now of one of our plaintiffs. Ruth so wonderfully summarized a couple of our 19 plaintiff stories. And now you're going to hear directly from Anne, who, let's see.
This, for me, is an issue that smacks just to the very core of a democratic society. The legislature has seen that the vast majority of people in this state want maps that are nonpartisan. They want to be in districts that make sense, where there are common connections with people. A district that is made up of little slivers of 5 different counties and only the most rural part of this county makes absolutely no sense. I have seen how unresponsive our legislature has to be because they're guaranteed to get reelected. I hope that we get a process in place that is going to ensure from this decade moving forward, when that census data comes out, that there is a process in place that is fair and equitable, keeps communities that have commonalities together, and that at the end of it all of us feel like we have our voices being heard and that we have elected representatives who are responsive to what we want to see happening.
Okay, so now we are moving into the question and answer portion of the briefing. So if all of the legal experts will turn their cameras back on. And we're going to start with a question from Alex at Bloomberg. And this question is going to go to Dan first. Oh, whoops, that's not the question we're going to start with. I'm sorry. We will get to your question, Alex, I promise. We're going to start for Dan, question from Scott Bauer with the AP. Why did you not challenge the congressional maps? Lots of people are asking that question. So tell us, Dan, why not the congressional maps?
Thanks. I should introduce myself. I'm Dan Lenz. I'm staff counsel at Law Forward, and so happy to be part of this amazing team and be representing these amazing petitioners in this important effort. Yeah, it's a great question, and it is one that we've seen a lot in the chat. Today, we're laser focused on the state assembly and state senate maps. These maps particularly, as Doug and Mark and Ruth all explained, have been controlling our state for about 12 years since they were passed in 2011, and really affect everyone across the state. And so we are starting there. This is a first step, and we are asking the court to make certain declarations about what the Wisconsin Constitution requires for partisan gerrymandering, or what it says about partisan gerrymandering. But today we're focused on the legislative maps and trying to get some relief there.
Thanks, Dan. Our next question is going to go to Mark, and it is from Alex Schur at the State Journal. So it's a little bit longer. I'm going to read it all to you, Mark. In her dissent in the last redistricting case, Justice Karofsky called the Wisconsin Supreme Court ill-equipped to take on redistricting litigation and said, in future redistricting cases, I hope that we will permit a politically insulated federal court to manage the task. Why should the Wisconsin Supreme Court take on this case today?
Thank you, Nicole. That case was about the one person, one vote requirement under the US Constitution. After each decennial census, states have to redistrict, and that's largely a federal claim. This, as the US Supreme Court said in the Rucho case, if litigants want to challenge plans as partisan gerrymanders, they need to do so under their state constitutions and in state court. And so the Wisconsin Supreme Court is the only court that has the power to adjudicate these claims. And so we have no choice but to bring them here, and we are happy to do so.
Thanks, Mark. Okay, our next question is from Scott Bauer, and a couple of other folks have this question as well, but this, Jeff, if you maybe want to start with this one, is the goal of the petition to have the courts draw the maps? Are we asking the court to draw new maps, or are we going to submit a map?
It's a great question too. This case, as we envision it, is going to unfold in a couple of stages. We're starting by asking the court to state that the current maps are unconstitutional. Once it's done so, obviously, we then need new maps. So how do we get there? Well, the court's going to have a lot of say in how we get there. The court will have a number of options, and it could ask the parties to submit maps, and I'm sure others would be willing to do so. The court can assign a special master or an expert to budget fairness, and we'll be following the court view in how it wants to handle all of these issues when we get there.
Jeff, we kind of lost your audio at the end. Do any of the other experts, would you like to say anything about maps, or we can move on to?
I think Jeff handled it. That we'll you know, the court has options, and in some ways it's really up to how the court would like to proceed. Some courts often like to have an independent special master provide recommendations, and that's certainly an option here.
Great, thank you. I'm going to go back to you again, Dan, for this one, or to start off with this one. And this is from Alex at Bloomberg. Your suit would require the overturning of precedent from 2 years ago, requiring a lease change to existing maps. How do you overcome that?
Well, I don't want to accept the premise that it requires overturning precedent. The case from 2 years ago, as Mark explained, was a decennial redistricting case arising out of an impasse between the legislature and the governor as to what maps would be in place. And that was the role that the court had there. As we explain in our petition and in our memorandum, we're in a very different position here, and for two reasons. One, the constitutional infirmities that we describe in our papers are just widespread. Even if you just look at the contiguity issue, that one claim that we have affects 55 of the current assembly district and 21 of the current Senate districts. You cannot draw a lease change map that addresses all of the constitutional infirmities that these maps reflect. And the second is because of the different posture of this litigation. When the court imposed the lease change methodology in last year's case, or in the 2021 case, it was doing so in part because out of deference to the political branches who had passed these maps in 2011. We don't have that here. These are court-imposed maps that failed the political process and aren't to be accorded that type of deference. So I don't know if the court, we're not saying the court necessarily needs to overturn that precedent. It's a very different case, bringing very different claims, and the court will address that appropriately.
Thanks, Dan. Okay, let's see. I'm gonna ask you, Doug, to answer this one. It's a question from J.R. Ross about timing. Are you asking the court to meet a timeline to have a new map in place by the 2024 elections if you're successful?
We are asking the court to have a time by which it imposes new maps. And let me just point out as an initial matter, this is no different than the court does in every redistricting cycle. Back in 2012, when we brought the Baldus case, we had new maps in place from the federal court by April 12th. I think it was something like that, 2012. When we brought the Johnson case, we asked the court to have new maps in place by early March, and it did. Those got vacated by the U.S. Supreme Court, but we had new maps in place just weeks later. This is something that happens all the time. So it's not an unusual circumstance to ask the court to do this by next spring. The answer to the question in terms of a date is yes, we're asking the court to have maps in place by the same date essentially that we had asked for in the Johnson case, and it's March 19th this year, and it's tied to the electoral calendar in Wisconsin, and when certain notices have to be sent out to clerks. So there is some play there. It could take a little bit longer, but we are asking for a date that's consistent with what we asked for before and what's been done by the courts in virtually every single redistricting cycle.
Thanks, Doug. We've got a couple of questions about this, so I'm going to try to combine them both, and maybe Ruth or Mark want to jump in on this one, but let me see how to best combine these. Okay, so did you decide not to challenge the current congressional maps in part to limit the chances the case would go to federal court is one of the questions, and there's a related one about, are you concerned about the case becoming a quote unquote independent state legislative theory case and concerned about the US Supreme Court coming in to rule on it.
I'm happy to jump in on that. Yeah. So because we are making claims under the state constitution, it is appropriate to file in state court. We don't have any federal claims, and so there's no need to go to federal court. And then that sort of, as the other question suggests, means that the independent state legislature theory is not applicable here, right? That is a theory about Supreme Court review, review of Supreme Court decisions to the extent that they involve the federal constitution. So in this case, US House maps, and these are only involving the state assembly and Senate. So the independent state legislature theory is not relevant to this case, and we are only making state claims. I don't know, Mark, if you have anything to add.
No, I think that covers it.
Great. We're going to go on to another question. Jeff, maybe we'll start with you on this one. Why did you name senators as defendants and not members of the state assembly?
See if that, can you hear me now? Good. Because every member of the state assembly is up for election in every 2 years, right? So if we're trying to get fair maps for the 2024 elections, all of the assembly districts are already up, and half of the Senate districts will be up for election in 2024. So we don't need to name those senators because those districts will be reelected under new fair maps. The only reason that the other senators are named respondents here is that they represent districts that, because of just the general electoral calendar, where we elect half the Senate, they go for 4-year terms, and half the Senate is on one 2-year cycle and half the Senate's on the next 2-year cycle, that those senators would not be up for election. And to make sure that we have fair maps and a legislature that fairly represents Wisconsin based on those maps, we need to have the entire legislature constituted under those maps. So we've named only those senators who would otherwise not be facing re-election in 2024. And we're asking the court to have those people face election under the new fair maps.
Thanks, Jeff. We have a sort of a general question, so I might just throw it out there to all of you. Would anyone like to talk a little bit more about some of the specific districts where our plaintiffs are from? I think, Ruth, you look excited.
I am excited. So I will, I mentioned her first, Rebecca Clark, right, in Sheboygan. It's just a very nice example of cracking. Sheboygan is a city that is basically the right size to be roughly a legislative district. So you could draw that district and it would be competitive, but probably lean slightly Democratic, and that would reflect the underlying voters. Instead, you have, I've got on my wall, districts 26 and 27 that split Sheboygan in two. And so that is an example of those districts we think are contributing to this bias that Mark mentioned in favor of Republican voters getting their legislative representatives in a way that Democratic voters are not able to translate their votes also into seats. And then another example is one of our other petitioners, Gabrielle Young, who lives in Madison. She lives on an island in that she lives in regular old Madison, but because she's in District 47, her little piece where she lives is completely unconnected to the rest of District 47. So from the perspective of being non-contiguous, it's non-contiguous and she's sitting outside away from everybody else. So that's another example.
Can I just jump in? And one thing we see a lot of folks defending the gerrymandered maps by saying, oh, this is just a function of Wisconsin's political geography, that Democrats all live in Madison and Milwaukee. And so you're just going to end up with districts that are, packed full of Democrats there. And that's just the way it is. That is a smokescreen. That is not true. There are a diverse array of political viewpoints across the state of Wisconsin. So in the mid-sized cities across the state, I'm from Rhinelander. That's a city that typically votes for the Democratic candidate in elections. Wausau, Stevens Point, Superior, Green Bay, La Crosse, all across the state, Sheboygan, there are districts that are drawn to ensure that the voters in those cities will never be able to elect their preferred candidate. that instead they'll have their vote swamped out by a majority of often folks living in more rural areas, and that don't, and the connections of the districts don't make sense. The Wausau, for example, is combined with farther out rural areas from the city rather than its neighboring suburban communities, and that doesn't make sense. It doesn't make sense from a partisan standpoint for sure, but more than that, it doesn't make sense from just a representational standpoint. The person that represents these cities ought to have some concern about their issues. The mayor ought to be able to contact that person and have a receptive ear. And you don't have that when you're solely focused on a partisan goal and not at all concerned about actual representation and real issues that people care about instead of ideological extremity.
Yeah, if I could add one more thing just on the idea of political geography that Mark raised. That was raised in the trial in the Whitford versus Gill case back in 2016. That was the explanation that the legislature gave for the extreme gerrymander that it has. And we disproved that. We submitted evidence to a 3-judge federal panel in federal court here in Madison. The legislature, I should say the Elections Commission, was able to submit its own evidence, and the court rejected the evidence suggesting that political geography, where Democratic and Republican voters live throughout Wisconsin, that's what was responsible for this lock that the Republican Party has in the legislature. Mark called it a smokescreen, and that's exactly what it is. There is a slight natural advantage that Republicans have, and that was reflected in the maps that I mentioned before were put into place by federal court in 2002. But there is a big difference electorally between a small advantage for Republicans that's inherent in a map and the ability of Democratic voters to be able to elect their candidates to office. A big difference between that and what we have now, which is a partisan gerrymander so extreme that there simply is no way that Democratic voters can elect a majority in the Assembly and the Senate.
Thanks, Doug and Mark. We've got a follow-up for Ruth. Did the group not bring a challenge to the federal map specifically to avoid issues that could arise with an independent state legislature theory?
Yeah, thanks for that follow-up, Alex. We are not shying away from filing a suit against the federal maps, but this claim is only about the state assembly and Senate, and as you know, they're nested districts, and the claims are only state claims, which is why it's in state court. So that ISLT is just not relevant in this case.
We've got a follow-up for Jeff. Would the senators named in the suit then have to run again in 2026 when they would be up for re-election under the current maps?
They probably would. This would be a special election because of the change in the maps. And it's simply necessitated by how egregious the gerrymander is and the need to restore constitutional norms and values.
Great.
Nicole,
okay.
Could I ask?
Go ahead.
Just one other point that was raised before, and this question about why are we not challenging congressional maps? As Mark had outlined, one of the major problems with the current state legislative districts is the non-contiguity, and that is something that's inherent to these assembly and Senate districts. It is such a facial problem with these. It's such a failure that it certainly makes sense to challenge those maps first on that basis as well.
Thanks, Doug. Mark, we're going to throw this question to you for the national perspective. Seems like every day you're at trial in some other state, so you are best positioned, I think, to talk about how unique is the extreme partisan gerrymander in Wisconsin state legislature in the national context. Have similar challenges been filed in other states? And can we look to some of those states as a roadmap for what's happening in Wisconsin?
Yeah, the Wisconsin map is unique. It is, I think, probably the most extreme of the gerrymanders, and there are some extreme gerrymanders across the country. But some of the stats I talked about, if you look at a state that is evenly divided, to have a legislature, and that's with a political geography where there, as I just said, where there is a diverse array of political viewpoints of the residents across the state. You know, certainly some centering with the Democrats in the cities and the Republicans in the rural areas, but there are, you know, a range of cities across the state of Wisconsin that have these voters, and in states where that's the case, where you have that, it is just almost unheard of to have a map that looks like this, where one party is getting 2/3 of the legislative seats. And so this stands apart among the 50 states as probably the most extreme that I have seen. But there are certainly challenges that have been ongoing in other states. So, you know, a number of states have ruled that partisan gerrymandering is unlawful under their constitutions. We just saw this in New Mexico, Pennsylvania, New York, Maryland, Alaska, and others. And so certainly we're not asking the Wisconsin Supreme Court to do something that is not what other state courts have held with respect to their similar constitutions. So if anything, the extreme nature of the maps here make this just an easy case. I mean, I don't think anyone can argue that voters in Wisconsin are being treated equally. The like fundamental principle that we all have the right to under our constitution, our state constitution, that to be treated equally under the law with the rest of your residents. If you and folks that vote like you are not allowed to ever have your votes turn into representation, that's a very plain violation of equality principles.
Thank you, Mark. Just to answer a lot of the questions about the filing that folks have had, as soon as we get the file stamp copy from the court, we will make it available on the Law Forward website, and we will make it available to anyone who would like to read the 145 pages of it. Ruth points out that there are really great explanations in the filing about the non-contiguity issue, and you can see pictures of what it looks like in some of the actual districts. Okay, let's see. What else do we have? So there's a question to talk a little bit more about why this case is different and why this case is not similar to some of the Wisconsin redistricting or cases that have been filed in the past. So Doug, do you want to start with that one?
Sure. Cases, the most fundamental point is the one I think that Ruth had made before, which is cases in the past have been filed in federal court. 2012, the Baldus versus members of the Government Accountability Board case, 2015, Whitford versus Gill. Those were all cases that were based on claims under federal law. We were going to federal court in those cases, and we were prosecuting federal claims. This case is entirely different. This is very, very new, and this is different. For the first time, we are coming to court, litigants are coming to court, and we are raising claims under provisions of the Wisconsin Constitution, and just the Wisconsin Constitution, that really have not been argued before. So it's just an entirely different type of case than has been filed before.
Can I add a note to that? Part of what this case brings forward is information that this court, members of all legal interpretation and judicial philosophy, have told us they want information about the history of our Constitution, how it was interpreted in the early days of our state, historical evidence as to the meanings of certain words. That type of information has not been brought to this court before to help it interpret these specific provisions and how they apply to partisan gerrymandering. We've heard the court, we've heard what they would like us to bring forward in terms of arguments and evidence, and that's what we're seeking to do here.
Thanks, Dan. Okay, let's see. We've got a question about the maps again. And Jeff, maybe we'll kick this one to you. Are you filing a demonstration map with your lawsuit? If so, what's the partisan lean of that map in the Senate and the Assembly?
So as I explained earlier, we're starting with the bedrock question of, are these maps currently unconstitutional? And we believe they absolutely are. So we are not filing a demonstration map at this point. We will be happy to file maps at any point that the court asks for them. And in terms of partisan lean, what's most important is that the court make sure, whether it is choosing a map that's submitted by different parties, whether it is working with a special master, however it is generating maps, what's most important is that the court make sure that the maps meet constitutional thresholds and that they do not favor any partisan interest in trying to draw that map. So we're not filing a map today. And were we to, or when we get to a point that we are filing a map, we will be attempting to file a map that meets all the criteria and is fair.
Great, thank you. Okay. Well, we're gonna get some clarity on the senators again. So, okay. So you want every senator who is scheduled to have an election in 2026 to instead have one in 2024. And would those senators then get a 2-year term? Otherwise, how do we keep the staggered terms? Jeff, you've been speaking on this. You want to?
I'll try again. I fear I'm not being clear because there are more questions. But yes, Patrick, that is correct. So folks who represent odd-numbered Senate districts who have their elections usually in the off years with the statewide office holders rather than with the presidential. We're going to ask that they face a special election in 2024, which is not part of their usual cycle. And that special election would be for a 2-year period, and they would go back onto their regular election cycle in 2026.
Okay, we've got another one. We're gonna go to you, Dan. Are you worried that this litigation could raise partisanship in the state court system, meaning that we'll have drawn out gerrymandering fights in court every 10 years with the political winner depending on the makeup of the Wisconsin Supreme Court?
No, and here's why. I mean, we're lawyers, we're bringing a lawsuit, we're bringing it to court, and we're making arguments that are not political in nature. They're not seeking to impose a political fiat, it's trying to end one. And the arguments we're making are deeply rooted in the text, the history, the meaning of the Wisconsin Constitution. These are legal questions for the court to answer. We expect that the court, on both, whomever the justices are, will give the matter a fair hearing, will consider our arguments, and will write a reasoned legal opinion. That's what courts are supposed to do. It shouldn't be a partisan matter. It should be a question of properly interpreting these constitutional provisions and applying them to the maps that we have, which are so plainly unconstitutional.
Nicole, could I add one other thing? As I mentioned before, one of the very popular policy positions that Wisconsin voters would like is a nonpartisan redistricting commission. That will never happen as long as a partisan gerrymander is in place. The point here, and I agree, there's a concern that if political issues are avoided by the legislature and they're kicked to the court, that the court becomes the vehicle for that kind of a policy change, and it's just going to flip back and forth. So the whole point here is, let's end the gerrymander, let's get rid of it, let's get fair districts in place, let's get some good redistricting reform, and then these kinds of policy issues, these big political questions, can go back where they belong. That's to the legislative process, not the court.
And I would just add one point to that, which is that when courts enforce rules that partisan gerrymandering is unconstitutional under the state constitution, you see that legislatures stop doing it because they realize that they're going to lose and spend a bunch of taxpayer money in the process of losing. So I would actually expect to see the opposite outcome from the premise of the question, which is that it might start to fix things going forward and stop this kind of abuse if the folks know it's not going to work.
Okay, we've got one more question on contiguity, which hopefully folks will be able to see once they are able to look at the papers. But these non-contiguous islands you speak of, are they not technically connected by a street or some narrow line?
No, some of them are miles away from the rest of the district, with upwards of 1,000 people living in them. There's one example we cite in the complaint, a part of District 47 that was formerly part of the town of Madison, has 654 residents in it. It's near Maple Bluff, and it is, 2 whole assembly districts away from the rest of District 47. And the town of Madison no longer exists. After the map was put into place, it became part of the city of Madison. So now there's just bits and pieces of the city of Madison that are in different assembly districts than the person a street over, and with hundreds of people in them. And they're not even bounded by any sort of municipal lines. And this is what happens when you aren't focused on drawing together like communities, and instead your focus is on achieving partisan ends. And so if you just zoom in and look at the map, it looks nothing like any other map across the country. There are little bits and pieces scattered all over the place. And given the express requirement of contiguity, it's kind of baffling how we got to this point. But no, there are just perhaps 1,000 or more little pieces that are not connected in any way to the mainland of their district.
Thank you. Okay, so we're gonna end with this last final kind of big picture question. Could someone describe what you think the national significance of this lawsuit is?
Clearly the main significance is for Wisconsin voters, but just having litigated Whitford and it being the first case that ever actually, like, a federal court struck down a partisan gerrymander, Wisconsin was at the forefront of this movement. And in response to the Supreme Court saying, don't bring those cases to us, go back to your state courts, I think that the national significance here is that Wisconsin is doing exactly that. It is remaining at the forefront of the challenge against partisan gerrymandering, which we see across the country. And so hopefully it can once again be at the vanguard.
Thank you, Ruth. Anyone else want to weigh in on the national significance? All right. Well, thank you all so much for joining us today. Just a couple of logistical updates. If you have additional questions, you can always send them to media@lawforward.org, and we will try to be as responsive and get back to you as quickly as we can. We are really excited about this filing today. We look forward to talking with you all over the coming weeks and months about how it develops, and really just happy to be here on this momentous day with everyone. So thank you so much.